Move on to the substance of today's session. So this is one of our online expert briefings on IHL, and today we're looking specifically at the international legal obligation to care for the wounded and sick, and what this means in practice in today's armed conflicts. Today's event is a special one in collaboration with the ICRC, the International Committee of the Red Cross, and is in the context of the updated commentary from the ICRC having recently been published on the First Geneva Convention. This updated commentary results from extensive research into practice over the last 60 years in relation to the provisions of the First Convention, as well as, of course, the articles that are common across the 4 Geneva Conventions. And this includes how states and national and international courts and scholars specifically have interpreted the obligation to care for the wounded and sick, which, broadly speaking, is an issue that I think many of you have had on your minds in the field of humanitarian action over the course of the last year. So very pleased to be welcoming today Lindsey Cameron, who will be giving the expert presentation for us today. Lindsey is a legal advisor for the ICRC, and prior to joining the ICRC, she was working as a researcher in the Faculty of Law at the University of Geneva. She's also worked with the UN High Commissioner for Refugees in the Balkans and in the Court of Appeal for Ontario in Canada. And very happy to welcome Lindsey back. She's also been a contributor to PHAP's on-site courses, which I think maybe a number of you have also participated in. So without further delay, then over to you.
Okay, thank you very much, Anurad. And I'm very happy to be here. Hello, everyone, and welcome. I'm really looking forward to discussing with you over the next hour on the care for the wounded and sick and the legal obligations in today's armed conflicts. Thank you again very much to PHAP for inviting the Commentaries Project to participate in these sessions with you. And also thank you, Anurad, for the very clear explanation of what the Commentaries Project is all about. So my remarks today, just so that everyone is aware, assume that you are all familiar with the main sources and rules on international humanitarian law, which is, of course, the body of international law that regulates the conduct of the parties to an armed conflict and that provides for the respect and protection of those not or no longer participating in the conflict or the hostilities. And I'll also assume that you're familiar with the commentaries that the ICRC had already published in the wake of the adoption of the Geneva Conventions, which many people know as the Pictet commentaries. So the Geneva Conventions of 1949 and also the additional protocols, which aimed to clarify the scope and the practical meaning of the provisions of the conventions. But just to reiterate, to be perfectly clear, the ICRC is updating the commentaries on the conventions. It is still the treaty text that remains the legally binding bit. So the commentaries themselves are not legally binding, but they aim to provide to capture the practice and evolution in the implementation of these obligations over the past 60 years. Okay, and also on the 9th of June, during the expert briefing that Bruno de Meer gave on the regulation of humanitarian activities, he presented the ICRC's project to update these commentaries in some detail. So if you are interested in more information on that and how the project has been set up and run, then you can find his presentation on PHAP's YouTube channel as well. It was on the 9th, and I think Marcus has provided you also with a link. So please go and look at that if you're interested. Just for those who would like to know now where you can find the updated commentaries on the First Geneva Convention, it's on the ICRC's website, icrc.org. You can click on the tab War and Law, and then on the Geneva Conventions and Commentaries. And then it does take a few more clicks, but you eventually get to this page the Convention 1 for the amelioration of the condition of the wounded and sick in armed forces in the field. And there you see you have the commentary of 2016, and you also still have the text right there of the commentary of 1952. So that's where you can find the updated commentaries. The updated commentaries on the Geneva Conventions, as I said, aim to reflect the law as it is interpreted today. But of course, this is a never-ending process, and the Geneva Conventions are living instruments, and their interpretation and application will continue to evolve. So this is not the final word on the matter, but it is meant to be an important tool in ongoing discussion on IHL. When we began the project to update the commentaries in 2011, we asked ourselves, which convention should we start with? The additional protocols? The Fourth Convention on the Protection of Civilians? Both of these obviously have a lot of relevance in today's armed conflict. There's a lot of debate about them. But we decided to begin at the beginning with the First Geneva Convention of 1949 on the wounded and sick, and this turned out to be a really good decision. First of all, it coincided with the campaign on healthcare in danger of the Red Cross and Red Crescent movement, and it's also a subject of, unfortunately, enormous relevance in today's armed conflicts. But it's also at the heart of the very first codification of international humanitarian law, which was, of course, in 1864, with the very first of the First Geneva Convention. So the protection of the wounded and sick that we'll be discussing today is really the starting point of international humanitarian law. And this protection is at least as central to reducing suffering in armed conflict today as it was 150 years ago. So during today's session, what I'm going to do is to present some of the findings on the updated commentary of the First Convention related to the obligation to care for the wounded and sick. And I'm also looking forward to engaging in a discussion with you and hearing some of your feedback and some of your comments on what we have found. So this first part of the presentation is sort of the official part of the presentation, and the official part is also the part of the commentaries that is online and that will soon be appearing in paperback in print. And for the second part, when we will be having an informal discussion, when you're free to ask questions, that I will be answering not in my capacity as ICRC person or on behalf of the ICRC, but in my personal capacity in order to enable us to have a freer discussion. And so my remarks won't necessarily reflect the ICRC's views once we are we're just talking questions and answers. Okay. So now when it comes to the protection of the wounded and sick, I'm sure that a number of you are especially interested in the protection of the wounded and sick in situations of violence that are not armed conflicts, situations of violence below the threshold, and in terms of what international human rights law applies, what is required, what about national laws, and all of the rest of it. These are very, very important questions, but these will not be dealt with in this presentation. This presentation and the discussion that we are having today is about the legal obligations in respect to the care of the wounded and sick in situations of armed conflict. And the reason why we have to limit it to that is because the Geneva Conventions only apply to armed conflict situations. And this is what the commentaries and the updated commentaries have looked at, is the armed conflict situations. However, that being said, many of you may already be familiar with the ICRC and the Red Cross and Red Crescent movement project on healthcare in danger, which is, of course, an initiative that is aimed at addressing the issue of violence against patients, healthcare workers, facilities, vehicles, to ensure safe access to and delivery of healthcare in armed conflicts and in other emergencies. And this project has already produced a number of practical and very useful materials, which of course exists alongside the commentaries. And if you are not familiar with this project, this is the website, and I really encourage you to go and to look at that material. And of course, the Commentaries Update Project and the Healthcare in Danger Project have been able to mutually benefit from each other, but here we are really limited to talking about healthcare in armed conflict situations, protection of the wounded and sick. Okay, so when it comes to protection of the wounded and sick, as I said, we have updated the commentary on the First Geneva Convention. And the First Geneva Convention applies to members of the armed forces who are wounded and sick and says they shall be respected and protected in all circumstances. So this is Article 12 on the First Geneva Convention. It applies in international armed conflicts. It's about the wounded and sick in armed forces. We have not yet completed the commentary on the fourth convention. This will be published, as you may be aware, in the coming years. We are also updating that. Many of the things that are relevant for the protection of the members of the armed forces are also relevant. Many of the standards will be and other things. So much of what we say is also relevant or is likely also to be relevant for the protection of civilians in international armed conflicts. I remind you that also in and I just show you that Article 12 is actually quite long. It has a number of paragraphs. There's a lot of material in it, and the commentary comments on all of these things. The things that I've highlighted on this slide for you now are the issues that really deal specifically with, or the passages that deal specifically with the protection and care of the wounded and sick. But of course, the commentary discusses all of the elements of the text of this provision. And of course, the protection of the wounded and sick is not only found in the First Geneva Convention, but also in the second for those at sea, in the third for prisoners of war, in the fourth for civilians, and of course we have the additional protocols that extends the protection to everybody. But as we are all aware, the vast majority of today's armed conflicts are non-international in nature. And what we have in Common Article 3, which in the Geneva Conventions is what applies to non-international armed conflicts, it says the wounded and sick shall be collected and cared for. So if we compare, I mean, simply the text of Article 12 and the text of Common Article 3, we can see there's a big difference in the amount of text that we have to discuss, to see what all of the obligations are and what they may entail. When it comes to non-international armed conflicts. But of course, the updated commentary on Common Article 3 has taken the opportunity to really explore the extent of the obligation and what is contained in Common Article 3. And just for the sake of interest, I show you Article 6 of the 1864 Convention. So as I mentioned, it was the very first convention on the protection of the wounded and sick in armed forces, which said wounded and sick combatants, to whatever nation they belong, shall be collected and cared for. It's almost exactly the same thing as what is in Common Article 3. And this is important because what has happened over the past 150 years with the Convention of 1906 and the revision in 1929 and then in 1949 is that the obligations in this simple article have been fleshed out in order to do all of the things that you need to do in order to carry out this basic obligation, which is to collect and care for the wounded and sick. So it's important that these two share the same root. And it's important for our understanding of everything that is entailed in Common Article 3 today. Okay, so who falls under the definition of wounded and sick? Now, this question is itself actually two questions. The first is what category of persons has to be respected, protected, and cared for? And the second is what counts as wounded and sick? What is the definition of being wounded and sick? So we're going to look at each of these. In terms of the categories of persons that must be respected, protected, and cared for, in the first convention, we have the members of the armed forces, as I mentioned. The second convention is the members of the armed forces at sea and also the shipwrecked. The fourth convention is civilians. You probably already know that the third convention is on prisoners of war. And then the additional Protocol 1 extends the same protection to all about the wounded and sick. Now, another category of persons that has to be respected, protected, and cared for is women. And if you look at Article 12, the paragraph 4 of the First Convention that I showed you a minute ago, paragraph 4 of Article 12 says, women shall be treated with all consideration due to their sex. Okay, so this was explicitly added to also to the First Convention. The reason that I point out this category is actually to highlight another difference between the Pictet commentary and the updated commentaries. In 1952, when they published the commentary on paragraph 4 of Article 12, women shall be treated with all consideration due to their sex, they wrote, what special consideration? No doubt that consideration which is accorded in every civilized country to beings who are weaker than oneself and whose honor and modesty call for respect. Now you can imagine that over the past 60 years, this has attracted a little bit of criticism. To be fair, this remark, which I think we can objectively agree is paternalistic in nature, it was a product of its time. And the commentary also referred to the reasons why the provision was needed. It was not all they said. So they acknowledged that there are already in the Second World War, there had been an increase in the participation of women in the armed forces. And it obliquely made reference to a lot of the violence that had been committed against women, although it didn't deal with that in any detail. But obviously, in 2016, we cannot say that the protection due to women is that which we would give to those who are weaker than oneself. And the Commentaries Project has really made an effort to bring the gender perspective in the commentaries up to date. And some of our peer reviewers have been really invaluable for this aspect of our work. So for this, we thank them very much. But in any case, the point here is that in international armed conflicts, and especially for the First Geneva Convention, the situation is fairly clear. Then, when it comes to Common Article 3, who must be respected, protected, and cared for? Who is wounded and sick? Now, in Common Article 3, it just says the wounded and sick must be collected and cared for. This is understood to mean members of the armed forces or civilians, and civilians. It really means both. But for this, we can understand easily that the wounded and sick who are wounded and sick as a result of the conflict, so for example, who owing to military operations or explosive remnants of war, or anything related to hostilities, who are wounded or sick, or some kind of contagion spread due to the conflict, which we would hope would not occur. These are obviously considered to fall under who is wounded or sick under Common Article 3. But in addition, we consider that persons whose medical condition or access to treatment is affected by the armed conflict, these persons are also wounded and sick for the purposes of Common Article 3. So a person's medical condition or access to treatment might be said to be affected by the conflict if, for example, the medical facility that they depend on is destroyed, where normally they would go for treatment, then they are also wounded and sick for the purposes of Common Article 3. When they don't have access to medical personnel or facilities that they depend on, or they have no access to vital medicines, but for reasons related to the armed conflict. So if for any reason related to the armed conflict, person cannot access medicine, medical personnel, medical facilities, the treatment that they require, under Common Article 3, we can consider that that person is wounded or sick, even if it's not because of the conflict itself, a wound inflicted or something else, that they are wounded and sick. Okay. So then, what counts as being wounded and sick? Now, in the Pictet commentary, they said it's common sense what wounded and sick means. And to a certain extent, this remains true. It is common sense. We know who's wounded, who's sick, all of these things. This is fairly self-evident, but it is also more complex than that. And so the commentary has gone into more detail, also because of questions that have arisen in the intervening 60 years since the original commentaries were published. So, for example, when it comes to battlefield And we're talking about the armed forces. Do the wounds have to be severe? These are new questions that have arisen. What kind of sickness counts? Is a common cold good enough? Does that make you wounded or sick and therefore protected and therefore everything else? And so the updated commentary has really tried to provide a more comprehensive answer to this question, also in light of the law that has been adopted since then. And it comes to the conclusion that there are two cumulative criteria that determine whether a person is wounded or sick. The first is that a person must be in need of medical assistance or care. Okay. The second is that they must refrain from any act of hostility. And the same definition is used for international and non-international armed conflicts. And this is for a number of reasons, largely because it would be completely illogical to have a different understanding of who's wounded and sick for international and non-international armed conflicts. It would make no sense, and there's no good legal reason for it. And the other thing is that those of you who are familiar with IHL, and especially with Additional Protocol 1, will recognize that these criteria, being in need of medical assistance or care and refraining from any act of hostility, these are essentially the criteria from Article 8, Paragraph A of Protocol 1. And at the time of the negotiation and adoption of the additional protocols, for Additional Protocol 2, they were going to adopt exactly the same definition for wounded and sick. But actually, there was a general movement to shorten the protocol, and all of the definitions got deleted. But the general understanding, even at the time, was that this would also apply in non-international armed conflicts. So what we have is a meaning of wounded and sick that is at the same time broader and narrower than the colloquial or ordinary meaning of the terms. So a pregnant woman isn't wounded or sick in the colloquial meaning of the terms, but she may well be in need of medical assistance or care, and in immediate need of medical assistance or care. So she would fall under the definition, as long as, of course, she's not participating in hostilities. And it's also narrower than the ordinary meaning of the terms, because even the most gravely wounded combatant does not come within the legal definition of wounded and sick if he or she continues to fight despite their wounds. Okay? With your dying breath, you can continue to fire your gun. You are not protected by IHL, okay, in terms of wounded or sick. Additional points that the commentary makes is that it doesn't matter whether it's an acute illness or a chronic illness. It doesn't matter whether the person was already sick long before the conflict started. If his or her access to treatment is affected by the conflict, then that person is wounded or sick in the legal sense. And this means that in addition to any other rights in national law or international human rights law, under IHL, that person must be cared for. Now, the commentary doesn't set out an exhaustive list of medical conditions for obvious reasons that count as being wounded and sick, but it does take care to emphasize that mental or psychological conditions also qualify for being wounded or sick, as long as they mean that the person is in need of medical care. And it does also specify that the illness doesn't have to be incapacitating. So it doesn't have to be to the level of Article 41 of Additional Protocol 1 for hors de combat. Okay, there is still a distinct standard in the general meaning of wounded or sick. Now, I mentioned you must be in need of medical assistance or care, and you must refrain from any act of hostility. I'm not going to go into detail here regarding the aspect of refraining from acts of hostilities in order to qualify for being wounded or sick in the legal sense. But the commentaries obviously do. They do deal with this, and I encourage you to look at that, both in the commentary to Comment Article 12 and Comment Article 12, Article 12 and Comment Article 3. And I do encourage you to go and look at them if this is an area that interests you. And I hope that you will find that it clarifies any questions you may have. Now, what is the geographical reach of the obligation to care for the wounded and sick? When we talk about the battlefield, we know Article 12 was originally meant to talk about the care for the wounded and sick on the battlefield, and then once people were further away and in a more secure facility, then there would be sort of a different standard of care. For members of the armed forces, they are protected when they are wounded and sick anywhere that IHL applies. Okay, anywhere that IHL applies, the person who is a member of the armed force who is wounded or sick is protected by IHL. For civilians, we don't need to spend too long on this, but simply imagine an armed conflict that is confined to one small part of a large territory. Are persons who are wounded and sick and not participating in hostilities, who are located far away from the hostilities, also covered by IHL? So as we understand wounded and sick to mean not only persons who are wounded and sick as a result of the conflict, but also medical conditions or access to treatment that are affected by the conflict, that means that a person does not need to be in the immediate area of hostilities to be considered wounded and sick for the purposes of international humanitarian law. And as we all know, once international humanitarian law applies, it applies in the whole of the state in which the conflict is occurring. And so a person may be remote from hostilities, but if that essential nexus is met, then that person would still be wounded or sick under IHL. Now, this is not to say that there's no nexus for members of the armed forces in international armed conflicts. There is. It's just that the nexus is met by the fact that they're a member of the armed forces in an international armed conflict. And so that's why, in a sense, the standard is the same. Okay, so now we know who we're talking about, who needs to be cared for. What type of care is required, and who has to provide that care? I'm going to start with the second part of the question. Who has to provide the care? So Article 12 is fairly easy and straightforward and clear. It says they shall be treated humanely and cared for by the party to the conflict in whose power they may be. Now, one of the things that the commentary points out about this is that this also means that you have to provide care also for your own armed forces. You may be in the power of your own armed forces and wounded or sick. And in those circumstances, your party has to care for you. Okay? This might seem self-evident now. It hasn't always been. But so it was important to also point that out. Obviously, however, one of the key elements is that care has to be provided to all sides, including to enemy forces, and without distinction. And something that the research for the Healthcare in Danger project has made clear is that there really is a need to reinforce the message when we're talking about IHL that providing care for enemy wounded and sick is not in any way a participation in hostilities, a contribution to the war effort of the other side, or anything else. It cannot be considered as anything other than a humanitarian act, and it's really, really, really important that this message is passed all the time when talking about the protection of the wounded and sick with any of the audiences, interlocutors, people that you talk to. It's a very important message. The other thing that I think is important to mention is that most healthcare professionals, when we talk about the fact that you have to provide care to all sides, is that most healthcare professionals will say, you know, a patient is a patient. I don't look at what side they're on. When they're on my table, I provide the care that I need to provide. End of the story. I don't think about it. And I think this is probably true for the vast majority of people. And this is a very good thing. I mean that, you know, doctors are able and nurses are able to just see people and as patients who need care. At the same time, I think that it's important to bear in mind that sometimes this really demands a lot of human nature. You may be a healthcare worker of a party, on the side of a party involved in an armed conflict, caring for persons on the other side. It may be a very violent conflict. You may be aware of very violent things that the combatants from that other party have been carrying out, and you still have to provide care. And in some cases, this will really demand a lot of people in terms of human nature. And I think it's simply important to be aware of it, that we can't take it for granted that it's an easy thing to do, but it's always an important thing to do, and it's a legal obligation. Okay, when it comes to Common Article 3, it says the wounded and sick shall be collected and cared for. It doesn't say by whom. However, it is understood that all the parties to the conflict must care for the wounded and sick. And so this means the state party to the conflict, if there is one, the non-state party to the conflict. And I think those of you who are familiar with the recent resolution of the UN Security Council on the protection of civilians in armed conflicts, 2286, especially about healthcare and healthcare in danger, will probably recall that that resolution affirms that really all parties are responsible to provide care to the wounded and sick. Now, the commentary also makes the point that this obligation means that non-state armed groups need to try to develop the capacity to provide medical care, and that they should train their armed forces in first aid when they are able to. But many of you may know that this is not always easy to do, especially for armed groups. But the commentary takes the position that armed groups really should be permitted to develop their ability and capacity to care for the wounded and sick. Now, there is no rule under IHL that says that you only have to care for a person who is wounded by your own armed forces. So the typical situation will likely be that all of the activities involved in protecting the wounded and sick, searching for them, collecting them, evacuating them, they will probably be carried out by the party involved in the engagement that led to them being wounded and sick, if it's this kind of circumstance for which a person is wounded and sick. Okay, so parties involved in the engagement, parties themselves, parties involved in the engagement. But the updated commentary also takes into account that in today's armed conflicts, there may be a number of parties, and that it may be that some parties who were not involved in a specific engagement also need to assist in the search for and collection and possibly in the care for the wounded and sick as well. So this is an important aspect to bear in mind. Also, if a party itself cannot carry out search, evacuation, collection activities for the wounded and sick in order to be able to care for them, it can call on humanitarian organizations to assist it. And if it does, it should make sure that there is safe passage for transports and equipment, try to provide transport routes and times that will not subject the personnel of those humanitarian organizations to the risk of mined areas or other obstacles. So it has to give them the tools to be able to get the job done if it's going to ask for that. Okay, in terms of the kind of care that is required, the basic rule is very simple. It's that the wounded and sick must receive the care required by their condition. This is quite obvious. If you receive care that is not required by your condition, you're either undergoing a biological experiment or you're not being helped at all. So you're not being cared for. So this is quite self-evident. It's also the language of the protocols, both Protocol 1 and Protocol 2. But this is not in the Geneva Conventions. And so it was important to show that the Geneva Conventions, the obligation to provide care, it's the same, okay? It's the care required by their condition. Now, the commentary also points to the usefulness of things like guidance created by professional bodies like the World Medical Association. There's a lot of guidance on medical ethics in times of armed conflict produced by the World Medical Association and other of these kinds of bodies. It, of course, acknowledges that medical standards may evolve and may change from country to country around the world. And obviously medical science itself evolves enormously. So we can't prescribe what must be done in each and every case, but simply that it should be done according to medical ethics, according to the best possible procedures that are known. Now, at the same time, this is an obligation of means that you must provide the care required by their condition. It's not an obligation of result. So that is, states and armed forces have an obligation to have medical services, right? They need to have something set up that allows them to provide care for people who are wounded and sick. But we understand that not every state or armed group has the capacity to provide 5-star state-of-the-art care for everybody. So the level of what is available and what can be done will inevitably change over time and from place to place. At the same time, it's important to underline that the Ethiopia-Eritrea Claims Commission acknowledged that there are these differences, that not all countries can be required to have the same standards for medical treatment, and that it will depend on their level of development. But the Claims Commission said scarcity of finances and infrastructure cannot excuse a failure to grant the minimum standard of medical care required by international humanitarian law. So the fact that you don't have much does not mean that you get away with doing nothing. You still have to do whatever you can with what you have. And the Commission also pointed out that the cost of such care is not substantial in comparison with the other costs that are imposed by the armed conflict. So meaning if you can afford to fight, you can also afford to care and provide care. So what this means, and what I think the commentary sets out, is that if a party does have significant medical resources at its disposal, it has to use them without distinction for everybody. If it doesn't have significant resources, it still has to do what it can and at least ensure the minimum. And again, even non-state armed groups need to try to develop the capacity and should be permitted to develop the capacity to provide medical care, and should do what they can to train their armed forces in first aid. Okay, now care also, we know, needs to be provided without discrimination. And I think all of you are completely aware, and for all of you it's obvious, that it would be discriminatory and a violation of the conventions to refuse to treat a person based on any of the usual prohibited grounds. So race, sex, religion, age, any of those things. Obviously you can't say we do not provide care to people over the age of 97. But we also need to be aware of a more subtle type of discrimination that can creep in, which might be not to provide care for a certain kind of illness that affects predominantly one group of people. If there's one group that is more susceptible to a certain illness, you know, it may be a kind of adverse discrimination without intending it to be, but it can still be discriminatory to decide not to treat that illness whatsoever. So parties need to be aware of all of these things. The fact that a party has to provide medical care to the best of its ability and without discrimination means that the standard of care has to be the same for its own armed forces and for enemy armed forces, but it doesn't mean that you have to do exactly the same thing. So if, for example, your own armed forces, you fly them out of the conflict zone and you provide them with 5-star care elsewhere, but you don't do that with enemy armed forces, it's not a problem as long as you provide the standard of care needed by that person to the best of your ability. Also, it doesn't mean that you need to provide, because you can, a state-of-the-art prosthesis for a person for whom you are treating. If the person receiving it doesn't live in a country where that kind of technology can be maintained. So it's not discriminatory to provide care and treatment that is adapted to the conditions in which the person is living. And you know, a person with a prosthetic leg, a simpler one may be much better in an area where they will not be able to have continuing care that would be able to maintain it for them. Okay, so without discrimination doesn't mean the same thing for all. Also, care must be provided with no distinction founded on any grounds other than medical ones. This is not specified in Common Article 3, but as it is a fundamental tenet of medical ethics, it's also obvious that it applies for there as well. And the final point is that care must not be interpreted to be limited strictly to medical care. It also may entail providing essential non-medical care, like food, shelter, clothing, hygiene items, all of these other things may also be required in order to actually properly care for somebody who's wounded and sick. And also, we mentioned earlier that we have endeavored to put a gender perspective, to include a gender perspective, but it's not only gender, but also more broadly. So the commentaries also encourage the parties to consider and take into account other elements that might hinder certain populations from seeking care, and for a variety of reasons, and to take steps to make sure that to facilitate the access to care of those groups. Okay, so it can also make sure that people, providing care may mean making sure that people will be able to seek care, okay, and will seek care. Now, the final question that we will touch on briefly now before taking any of your questions is what if a belligerent is not present on the ground? Now, this, of course, is a situation that I'm sure you are all very familiar with, and that is increasingly prevalent in some of the kinds of armed conflicts today. And so what does that mean for the obligation to provide care for the wounded and sick, and especially for persons that you and your party may have wounded? The commentary considers that, that takes the position, or expresses the position, that a party is not absolved of the obligation to care for the wounded and sick simply because it doesn't have forces on the ground. At the same time, there's no rule in IHL that says you need to have people on the ground just to be able to go and do anything under IHL. There's no obligation to have ground forces. So how do we resolve this tension? Well, first of all, I mentioned earlier that a party can contact humanitarian organizations when it knows that there are wounded and sick in a specific area, and it may be required to inform other actors like humanitarian organizations of their presence and to provide some kind of detailed information to enable them to be collected and cared for, and some kind of geographical coordinates. If it's going to do this, it would need to also provide the circumstances that they would require in order to be able to go and do that safely, obviously. Unfortunately, there may be some circumstances in which there is simply too much violence and not even humanitarian organizations have access. There's not much that can be said for those except to say that you are not completely absolved of your obligation. You have to do what you can, and so you must think as broadly and as widely as possible of all of the ways that you can engage with others to make sure that wounded and sick are collected and cared for. Okay, so with that, thank you very much for your attention. I think I've spoken longer than I intended to. But I appreciate your attention, and I look forward to your questions. Thank you very much.
Okay, great. Thank you very much, Lindsey. It was a very interesting presentation, and I can see very much appreciated. So we do have a number of questions that have come in. I will start with a question from Tewodros, who's based in Ethiopia. And Tewodros is remembering when you were talking about what counts as, quote, wounded and sick, and there were two criteria that you mentioned. The first one being that the person must be in need of medical care. And Tewodros was wondering, should this be decided actually by a medical professional? How is this supposed to happen in practice? Who would be qualified to make that judgment regarding the first criterion?
That's a very good question, and I don't think that we actually say specifically who gets to decide. But I think that a person who feels that they need to access medical care is a person who is in need of medical care. And so it's the individual themselves that would be able to, because otherwise it would mean that you would have to get to a doctor to ask a doctor, do I need medical care? And the point is that you need to be able to get to the doctor in the first place. So it's a very good question, and it's one that we actually didn't specify. But I think that, yeah, it has to be self-identification by the person themselves.
Okay, great, thank you. We have another question, really a question of clarification, I would say, from Firmin in Guinea, who is asking, do these protections that you've been describing, do they apply in internal conflicts in which governments qualify the other party as, quote, insurgents?
Yes, absolutely. I mean, no matter how if you have a situation of armed conflict, and that where you have two organized armed groups, one of which may be the government or may not be the government, as long as you have a standard of organization and you have an intensity of hostilities to create a situation of armed conflict, no matter how the government or anybody else qualifies the other party, whether they say terrorists, insurgents, or anything else, if it is a situation to which IHL applies, then all of these legal protections apply because IHL applies.
Okay, great. Thank you very much. So now a question from David, who I believe is based in Kinshasa, but David, correct me if I'm wrong. David understands from the presentation that Article 12 tells us that these obligations apply to a signatory state's actions or omissions vis-a-vis its own armed forces. If that's the case, does this also apply only during an armed conflict, or does it apply to that signatory state's actions or omissions vis-a-vis its own forces in times of peace as well?
So this is an interesting question. The commentary itself doesn't go into a lot of detail on where that would go. And I think here you would have a lot of overlap between the national law of the state and IHL. There are certain obligations in the conventions that apply in times of peace, which are things like, setting up the medical system itself. You would probably have to do that in times of peace. In terms of issuing all of the emblems to everybody who needs them, getting the emblem legislation, repressing the abuses of the emblem and all of those kinds of things. Those things you have to do in peacetime and in times of armed conflict. But when it comes to this sort of obligation to actually provide care for the wounded and sick in your own forces, I think it would probably be a step far to say that under IHL that continues also in peacetime, because I think that aspect of the obligation is one that is really focused on the armed conflict situation itself. At the same time, there's a certain amount of continuing care that may be required based on wounds or sicknesses that have come from an armed conflict, and those you might be able to make an argument that that obligation continues based on that. But this, of course, again, let me reiterate, now we're in the questions phase. This is not something that we've dealt with in the commentaries, and this is not an ICRC official position. This is my own response to your very interesting question. So it's, so take it in a personal capacity. I mean, I think the argument can be made for continuing care for things either contracted or wounds received and then consequences in an armed conflict. That's not an argument that the commentary goes into detail about.
Okay.
Yeah, I hope that answers your question.
No, that's great. Thank you very much. We have a question from Yanya, who's currently based in Switzerland. So first of all, wants to thank you for your presentation, and then on one of your last points concerning belligerents' duty of care to wounded and sick on the ground. Yanya wondering, would this also extend to UAVs, drone warfare by a belligerent?
Yeah, of course. I mean, any kind of situation where you have no troops on the ground, whether you're using drones, whether you're using airstrikes, with an airplane or anything else, you have the same sort of factual situation where you are not able to go and do something. Concretely, you don't have troops that you can send in, go collect and care for wounded and sick. So it's unlikely that that's going to happen. Now, one of the things that there's an interesting article, which is Article 18 in the First Convention, which says that civilians and relief societies may spontaneously provide care for the wounded and sick. They can also be called upon by the parties to the conflict. They can't be obliged to do it, but they can be called upon. But they can do it spontaneously. And one of the things that that the commentary to Article 18 points out is that the parties need to take into account the fact that when there are drone strikes, when there are these other kinds of airstrikes, there is this likelihood that people will rush spontaneously to look after the wounded and sick, and that they need to take into account that actually the proportionality analysis might change in between the first and the second strike, and that they need to be aware of that and adapt their attack accordingly. So, and this was, this is one of the ways in which sort of the thinking about the new technology, drone strikes and others, was taken into account in the updated commentaries. So that analysis you will find in the commentary on Article 18 of the First Convention.
Okay, great, thank you. So a question from Chris in Washington, D.C. asking, could you say a few words about the difference in care in Article 15 versus Article 12 of the First Geneva Convention?
Sure, thanks. Hi, Chris.
I guess you know which Chris we're talking about.
I'm assuming I know which Chris I'm talking about. Okay, so Article 12, I have shown it to you and you've seen. It's the one that members of the armed forces shall be respected and protected in all circumstances. Article 15, because you don't have it on the screen, I'll just mention, it says, at all times and particularly after an engagement, parties shall, without delay, take all possible measures to search for and collect the wounded and sick, to protect them against pillage and ill treatment, to ensure their adequate care, and all of the rest of it. Okay, traditionally speaking, Article 15 was sort of considered to be really the one that's really urgent battlefield care and the immediate after an engagement what you have to do. And so there was an understanding that the level of care that you would be able to provide in those kind of urgent battlefield circumstances might be more limited than what you are able to do in a more secure facility. And that the care that Article 12 is talking about, and especially paragraph 2, where it says a person's in the power of a party to the conflict, means that that person has been moved to a place where it's a more secure area and they would be able to be probably cared for to a maybe higher level of care, and all the rest of it. Also, I would just point out that you can see Common Article 3 says the wounded and sick shall be collected and cared for. It's sort of an amalgamation of 15 and 12, because the obligation to collect, to search for, and all of the rest of it is in a separate article. It's not in Article 12, whereas in Common Article 3, it's in the same. So, I mean, traditionally, there were these two different levels of care that were anticipated. I think the approach that the commentary has taken now is that all of it is an obligation of means. And so in any circumstance, you have to do the best that you can do given all of the surrounding circumstances, which will include the security of the area, which will include your level of development, the level of training of your own armed forces, what you have available, and all of that. And so there is less of this idea of battlefield, hot conflict zone, and in a more secure area, although those will also be factors that will affect what you are able to do.
Okay, great. So we have a large number of questions coming in, but we are running short on time. So I'm going to combine a few, perhaps. We have a number of questions coming in specifically regarding mental health care needs. And to sum them up, perhaps would there be anything that you could share with us, Lindsey, about to what extent, in the process of reviewing the practice over the last decades, how to what degree has practice shifted, perhaps when it comes specifically to the situation of mental illness or mental health care needs in situations of armed conflict?
Well, that's a very good question. I think that when it comes to combatants, the question of mental illness started to become very prominent already with the First World War, as I think many of you will be aware of the idea of shell shock and people returning from the field and being not the same person as they were when they had left. So the idea of mental illness, mental health, and how to treat it also, has been around for at least 100 years. And the fact that it is something that also needs to be treated in armed forces, in a sense, I think it's not such a new question in some respects, because already for armed forces, when they had people who were not functioning because of the what we would now call post-traumatic stress disorder or something else, this is an issue for having forces that can continue to fight for you. And so this is an issue that they need to look at in terms of treatment and providing care and everything else, even for their own interests of being able to continue. So in that sense, it's not something that is completely new. At the same time, I think that when it comes to the wider population and an understanding of mental health and the requirement of care for things that are not so visible or not so obvious, obviously, yes, there have been enormous developments and recognition in that area. But I can't go into any more detail on that, but obviously it is something that is recognized as also in the additional protocol when it comes to being wounded or sick.
Okay, great. Well, thank you so much, Lindsey. We came to the end of our hour remarkably quickly. It was an excellent presentation and really, really a pleasure to have this Q&A discussion with you. So thanks so much for joining us, and congratulations to you and to the whole team for the excellent work, and looking forward hopefully to another presentation in the near future. So thanks again.
Thank you very much. I really enjoyed being with you. Many thanks to you, and many thanks to all of you for your questions. It was really interesting.
Thanks. All right. So looking forward to seeing all the rest of you as well in the next online session. And in the meantime, this is Inherit Lang and the team from PHAP signing off from Geneva.